Today, we're going to be speaking with Dan Canon, who's a civil rights lawyer and a law professor at the University of Louisville. He is also author of the book Pleading Out: How Plea Bargaining Creates a Permanent Criminal Class. Dan, really great having you on. I appreciate your time.
Hi, David. Thanks for having me.
So, I think maybe to start, it would make sense to talk about how this sort of like a plea deal industrial complex started. I think many of us intuitively know just because you've been charged with a crime doesn't mean that there will eventually be a trial and a verdict in the way that we watch sometimes on television in major trials. How did this develop that many cases don't make it to trial? Who was motivated to make that the reality?
Sure, and I would go so far as to say almost all cases don't make it to trial. Where
Right.
we're sitting at right now is a 97% plea bargain rate, which is, just to sort of grasp the how big that is. That's three out of every 100 criminal cases that might go to trial, right? On average, and that's the entire country. This is way, way, way far beyond what anybody else is doing in the rest of the world. The rest of the world, even in comparable legal systems, places like the United Kingdom and Canada and so on. I mean, the highest you get is to 80%, and even that is kind of extreme. So nobody does it as much as we do, and what the result has been pretty much the death of the jury trial altogether for all intents and purposes. The community has been completely removed from processes of criminal justice. And if you look historically at how and why this originated, this uniquely American thing that we do, you got to go back all the way to the beginning of the 19th century, and look at the early labor movement in the United States. And when that was gathering steam, that is the same time that the plea bargain sort of took off in New England, right? So you have this post-industrial revolution situation where the working classes are getting bigger and bigger and bigger and bigger. And up until 1830, plea bargaining was taboo. There was, you would see prosecutors actually get prosecuted for trying to make deals with defendants in the way that they do now. So it was completely off the table and just wasn't happening, or if it was happening, we didn't know about it. Then in Massachusetts, you see that number tick up very quickly. By the 1850s, it's 50% of all criminal cases are ending in a guilty plea. By the 1880s, it's 88%, right? So almost all criminal cases are ending in a guilty plea by the end of the 19th century in Massachusetts. And what's happening there is that there's this giant explosion of working class people, right? And at the beginning in the 1830s, the courts and every other American institution is working really, really hard to break the back of organized labor. You've got the first strikes are happening in the 1820s. And then the first Federation of Labor Unions happens in New York in 1834. And so the ruling classes are sort of panicking and trying to figure out, how to fix this whole thing. First thing they start doing is prosecuting groups of workers under conspiracy statutes. So you get big groups of them at a time and say, all right, you're going to get together and try to get higher wages or, shorter work days or something like that. And we're going to prosecute you for a conspiracy. And it becomes pretty apparent early on that that's not going to work. By the 1840s, they've sort of scrapped that whole idea because there's just too many of them. And the working classes are getting too big, and there's working class people for the first time sitting on these criminal juries. So the response of the ruling classes at that time, as I talk about in my book, is to, number one, take a lot of power away from juries. Juries are not nearly as powerful now as they were back then. And the other one is to introduce the plea bargain. So what that allows them to do is to quickly and quietly prosecute lots of individual workers one by one, rather than trying to smack a whole bunch of them at a time with the hammer of the criminal law, which they knew that wasn't going to work. They were just too outnumbered.
In the modern era, what is the advantage? We'll talk first about the prosecutors. It seems if everybody went to trial, they would not have nearly the workforce that would be required to try that number of cases, right? It just seems like an impossibility.
Yeah. So what you see in situations where in the few situations where you've actually reduced the number of plea bargains is that it does force prosecutors to make tough decisions. Okay? So you look at the historical example of Alaska. For a very brief period of time in Alaska, you had an attorney general come in and say, you know, this is we're going to stop doing plea bargaining. We're going to reduce the number of plea bargains. Like all the plea bargains are going to come through me.
Yep.
And what I've heard since I was in law school is that if somebody does something like that, it's going to crash the whole system, right? Like we're just not going to have a criminal justice system anymore because the wheels of justice are going to stop turning, and all these jury trials are going to make it to where we just can't do anything.
Right.
But that's not true if you look at the historical example of Alaska and some of these other places where this has happened. What happened in Alaska was lots more cases went to trial. But the system didn't crash, it adapted and it got more intelligent. So at the point in time in Alaska where this new attorney general took over, the Alaskan prosecutors were rejecting about 4% of all the cases that police brought to them. So cops would come in with a case, and if it was a bad case, if it was a good case, it didn't matter because the prosecutors knew that they could push somebody into some kind of plea bargain and get a conviction, right? Taking plea bargaining off the table means that the prosecutors have to be more selective. And so what happens right off the bat is that the prosecutors go from rejecting 4% of all those cases to rejecting 40% of all those cases. So that forces prosecutors to make decisions, right? To come up with priorities for what they're going to prosecute and what they're really, what the community's priorities really are. And so far from crashing the system, it adapts. It becomes more intelligent. The prosecutors are making more intelligent decisions, and that forces the police to cross their T's and dot their I's and do more diligent homework. And so if you think about the situation that we have now, police know they're going to get a conviction. They know that they're going to, they out of most of the 11 million arrests that happen in the United States every year are going to result in some kind of conviction. And so they don't have to have any real evidence that a crime was committed. They don't have to, they're not anticipating that they're ever going to be put on the stand or have to account for the charges that they've levied against somebody in any sort of meaningful way. And if you reduce the number of plea bargain cases, even just by a little bit, that whole situation starts to change because police know that the case is more likely to go to trial, and so they have to be more careful in what they bring to prosecutors in the first place.
Now, from the standpoint of the defendants, the accused, I think many of us have this instinct that if we were ever in such a situation and we felt that we were innocent, we would fight to the end and demand a jury trial and so on and so forth. What are the incentives that are there for those who are charged to end up taking plea deals?
Well, it's every incentive in the world, isn't it? So that's what we've decided to do in the United States that's so different from the rest of the world. Here, we've decided that we're going to give every carrot and every stick to prosecutors so they can end up with a conviction somehow, right? Mm-hmm. So and this was all still sorting itself out by the late 20th century. And then there was this Supreme Court case called Bordenkircher versus Hayes, where you have right down the road here in Lexington, Kentucky, you've got a 29-year-old black horse transporter who gets picked up for trying to cash a bad check worth $88, right? So he writes a bad check. Prosecutor comes to him and says, "Oh, it looks like you were in trouble 10 years ago over something. And so what you're going to do is for this $88 check, you're going to take 5 years in prison." And Paul Hayes says, "I don't want to take 5 years in prison." Prosecutor says, "Well, if you don't take 5 years in prison, then I'm going to hit you with this habitual offender charge, and that carries a mandatory penalty of life in prison." And he's like, "I don't want to do life in prison over an $88 check," but that's the kind of power the prosecutor has. We're still sort of sorting out whether or not we wanted to do that. In that case, Paul Hayes didn't want to take the deal. He went to trial, got convicted, and got a life sentence. And that case went all the way up to the Supreme Court. And the Supreme Court at that time in 1978 essentially says, yeah, it's the prosecutor's job to persuade a defendant to give up their right to trial. And they can do that by hook or by crook. They can do whatever they want to get a defendant to plead guilty and to forego as the prosecutor says, the inconvenience of the trial. And so that case sort of throws the floodgates open for prosecutors to use anything and everything that they want. So, if you have, if you're charged with murder, let's say, the prosecutor can offer carrots, can say, look, we're going to bust these charges down to a wanton endangerment, and you're going to do 6 months probation because I just don't want to take it to trial, and I don't think it's a very good case, but I need a conviction. So, take it or leave it, and you'd be hard pressed to say, I'm going to leave that on the table.
Right.
Conversely, if a prosecutor wants to proceed as though it is a death penalty case, and threaten a defendant with literal death if they don't take a plea bargain to, let's say, life without prison, they can do that too. And in fact, when you look at the numbers, one of the more chilling statistics that I've got in my book is that since the 1970s, 75% of the people on death row could have avoided a death sentence by taking the plea offer that the prosecutor gave to them. So in other words, the prosecutor has the power to say, if you don't take this deal, I'm going to put the death sentence on the table. It's not on the table until you say yes or no. But if you make me go to trial, well, death penalty's on the table. So prosecutors just had this enormous power to alter the legal landscape in any given case that in the United States that they just don't have in other countries.
Is it easier for wealthier defendants to avoid taking plea deals in the sense that, all else being equal, a long trial costs more money?
Sure. For reasons that I said before, it's long trials cost more money, but they're also more high profile, right? They're more visible to the public. The media pays more attention to what's going on in these high profile cases. So you get somebody like a Jeffrey Epstein that's going to come in with quite obviously is guilty, but comes in with a team of 100 high paid lawyers that are going to make the prosecution work for anything that they end up with. And so the prosecutor starts to look at that situation and saying, all right, this is going to be very time consuming. It's going to be very difficult. It's going to be very expensive. And it could be very humiliating if we lose, right? This could have political consequences and all this other stuff. And it's going to be very much in the public eye. So rather than go through, the hoops of a trial, let's try to get them into a place where they're going to take a plea. And in fact, that is exactly what happened down in Florida with Jeffrey Epstein and the initial disastrous prosecution that feds tried to carry on there. And the victims were completely cut out of that prosecution. And Epstein got a slap on the wrist for, abhorrent conduct. And that is the kind of treatment that the wealthy typically can expect to receive in the United States. So when people talk about there being two different justice systems here, that's what they mean.
It seems the other component to this also is the use of pretrial detention and the ability to make bail. I mean, as a very general concept, I think it's probably more difficult to mount a defense, all else being equal, if you are being detained up until the time of your trial rather than out. Can you talk a little bit about that and the effect of pretrial detention and possibly the unequal application of pretrial detention on the sort of plea bargain chances, I guess?
Sure. So cash bail, like the plea bargain, is one of those things that we've carried forward, from an overtly classist system in the 19th century until now. Right. So, it's yet another gun that the prosecution can put to a defendant's head to say, like, listen, if you don't take this deal, you're just going to stay locked up there until we have a trial. And that could be 2 years from now. That could be 3 years from now. So if you can't post bail, tough luck. There you sit in the county jail. And these county jails, as I'm sure you know, are oftentimes not friendly places. They're so unfriendly, in fact, and especially metropolitan jails are so unfriendly that you see defendants taking deals where they end up going to prison just because prisons are a little friendlier than the county jail, right?
Wow.
For example, you see that a lot. But basically, it's this arsenal of tools that the prosecution has, cash bail being one of them, to make sure that every defendant gets pressed into taking a deal of some kind. I had a client that I represented in a civil rights case who insisted on his innocence in these criminal charges that were levied against him way out in rural Kentucky. And he sat there in jail waiting for his trial to come up for 3 years. Well, the maximum sentence that he could have come up with, that he could have been subjected to, was only 2 years on the original charges. So he sits there in 3 years waiting for his trial and then goes to trial and no police show up and they dismiss the charges. And so that is the kind of thing that for people that insist on their right to trial, they're going to get punished for it. It's what we call the trial penalty. It's what happened to Paul Hayes. It's what's happened to countless clients that I've had, and it's what happens all over America every single day.
In those situations, I think this was an issue with Donziger, in fact, when the strictest penalty you could get is less than the time that you've been detained pre-trial. Is there some recourse or remedy in those cases?
Well, you'd think there would be,
Yeah.
right? You'd think that, and that was, the case with my guy down in Eastern Kentucky.
Yeah.
But the federal courts are so hostile in most of the country to these civil rights actions that you're not very likely to get anywhere. And especially since this is such a common thing, like for people to stay in jail way longer than they should stay in jail for one reason or another.
Yeah.
That most of those folks that have been aggrieved by something like that in the system can't even find a civil lawyer to represent them to vindicate their rights. Certainly not in rural parts of the country where this happens all the time. And when they do find someone to represent them, the civil rights actions tend to fall flat on their face because you've got these judges that are hostile to these kinds of actions to begin with.
Right. The book is pleading out how plea bargaining creates a permanent criminal class. We've been speaking to the book's author, law professor Dan Canon. Dan, thank you so much for your time.
Thanks so much for having me.